Hi, everybody. This is Monty McIntyre, and welcome to Trial Alchemy. Today, I'm going to be talking with Judge Ken Medel, who is a member of ABOTA, and he has been involved in ABOTA for a number of years, but he is a graduate of USD School of Law. He worked as a prosecutor for the San Diego District Attorney from 80 to 87, and he tried 40 jury trials as a prosecutor. And then he had an extensive civil practice. He was with a well-known firm in San Diego, Ault, Deuprey, Jones, and Danielson, specializing in defending doctors in civil cases alleging malpractice. He then had a small partnership, Medel Rawers, where he did the same practice. And then he had his own firm, the Medel Law Firm, from 2000 to 2010, where he specialized in medical malpractice, medical board defense, and defense of police agencies and entertainment venues. And Judge Medel completed about 40 civil jury trials when he was a civil trial lawyer. He's been honored as the top attorney by the San Diego Daily Transcript and Attorney of the Year by the San Diego Defense Lawyers. He's had long associations, and he served as the president of several organizations, including the San Diego Inn of Court, which teaches lawyers how to try cases, the San Diego chapter of the American Board of Trial Advocates, ABOTA, and the San Diego Welsh chapter of the American Inn of Court. Judge Medel was appointed to the San Diego Superior Court in 2010. He completed several assignments as he rotated through both criminal and other trials. He served doing some criminal trials in the South Bay District. He did some juvenile dependency. He did criminal work. But he's also, for the last 8 or 9 years, been the presiding judge in the independent calendar civil department in the Superior Court of San Diego. So he is somebody who frequently participates as a judge for college and law school mock trial competitions. And he also helped found and coach the Patrick Henry High School mock trial team in San Diego. And without any further ado, Judge Medel, welcome to Trial Alchemy, and thanks so much for being a guest today.
Monty, thank you for inviting me to this.
Well, it's great to have you here. And in terms of your civil trial experience in the IC department, you've been doing that about 8 or 9 years now. And would you estimate you've presided over somewhere getting close to 100 jury trials to date?
Yes, something like that, Monty. It's hard to keep track. Sometimes it's more or less in a year, but if we said 6 to 10 a year for the last 8 years, or that's kind of where we'd be at.
Okay. Well, one interesting question that I like to ask guests on this podcast is if they've tried a case since we've come out of the COVID pandemic, and you, of course, have, and I think you've presided over several. In your experience as a trial judge, do you believe juries are acting any differently in their deliberations and verdicts after COVID than they were before?
Yeah, I really do. And, I consider the post-COVID jury panels to be heroic and staunch and ready to go. Meaning if they've showed up for jury service, they're generally ready to go. And I've been very proud of that. And even in the period where COVID was starting to wane a little bit, I think every judge in the courtroom had trials where COVID played an effect on whether you could go forward, meaning a juror or two would get sick with COVID right in the middle of the trial. And even then, as people were sort of not panicking anymore as much about COVID, it didn't seem to bother them very much. So I can give you a vignette that happened to me twice. And that is, we get the call in the morning from juror number 12 saying, I have COVID and I'm not coming in. And I say, okay. And I go out to the 11 remaining jurors and the alternates, and I say, juror number 12 has COVID. And a lady raises her, and I said, but we're moving forward. A lady raises her hand and says, I need to know more details about this. And I really believed she was asking that in a way to perhaps justify her being excused from the panel. And so I went back to my chambers. I got back on the phone with that juror and I got all the pertinent details, when it happened, what was the timing of it in relationship to his jury service, et cetera, et cetera. I came back, I laid it all out. I talked to my supervisor before I came back, which was my presiding judge at the time, Judge Smith, Michael Smith. And I said, what's the best approach? He says, I would offer to send them all home for a day and to test the next morning. And if everyone is okay, then they would just come back. So I came out, I explained that chronology to all the jurors, in particular to the one who asked the question. And I said, my supervisor says a good idea would be for everyone to go home and then come back tomorrow if you test negative for COVID. And that same lady who asked the question raises her hand and says, have you ever thought of just asking us whether we should just move forward? And I go, oh, no, I didn't. Let me ask. Are all of you willing to move forward? They all said, yes, let's get this over with, for God's sake. So we substituted in, just like we always would, substituted in an alternate, and on we went. I have found that the post-COVID jurors are all staunch and ready to go and really there to serve and ready to complete their task under any and all circumstances, including, the COVID situation. So,
boy, that's great.
Big difference.
I had the good fortune of being a member of a criminal jury in 2 occasions in the early 2000s in San Diego, and I was really impressed with the jurors once they're selected and they're serving. They were, in both cases, conscientious. They were listening. They were paying attention. They were following the instructions and deliberations. So, I think they really do a good job. And I agree with you. I think they are great at paying attention to the task and getting things done. Now, in terms of verdicts of cases, because you're hearing civil cases, do you think the verdicts are any different since COVID, or you think they're similar to pre-COVID pandemic?
No, I really didn't see a significant difference. And, Monty, that's kind of I'm not one to sort of generalize about things because each case is different and presents its own challenges. And
Right.
So it's hard to say, hey, generally jurors are giving more or less money these days, or generally they're finding more in favor of a defendant than a plaintiff these days. So I haven't really seen a perceivable difference in the outcomes or in the outcomes of the cases.
Okay, well, I'm going to give a little preview to the audience. What we're going to focus on today is more of, things to do in preparing and going to trial from the perspective of a trial judge like you, and giving some tips to people who maybe haven't had that much experience, because you're a very experienced trial lawyer before you went on the bench, and you're a very experienced judge at this point. Before we get into some of those nuts and bolts, let me ask you this. In your experience as a trial judge, what would you say is the most, I know everything's important, but what would you say is the most important part of a civil jury trial from your perspective and experience?
Well, Mon, I hate to be wishy-washy, but that's pretty case specific also. There are times in a certain case where I say there are 3 or 4 jurors on there. Why did they leave those jurors on there? Whether it's plaintiffs or defense or both. Sometimes I see a juror as being someone who's going to disrupt the process, and that might be bad for either one of them. So it's a gamble to leave a person like that on. And so, there are times when I could conclude that the outcome was affected by faulty jury selection, so to speak, and leaving people shouldn't be left on. I think the opening statements are good. Can be influential. As I was coming through the process, every time I went to a lecture or saw a seminar, it was always, oh, you are gonna affect them. Sometimes people would say at voir dire what you say. Then sometimes you know your opening statement is gonna be the cat's meow. And I really make a big point before the lawyers do their opening statement to say that this is not evidence,
Right.
and that the evidence is going to happen from the witness stand. So you can listen to them. This is supposed to be, the opening statement is supposed to be an aid to them to understand what the storyline is in the event that things come in out of order, but it's not evidence. You're going to hear the evidence from the witness stand in just a few moments. So take it with a grain of salt, and here we go. Monty McIntyre, go. And then you do your opening statement. So I honestly believe that the jurors do take that to heart and that they do listen carefully. Certainly, it's going to have an effect. Anything's going to have an effect. But I can't say that the opening statement is case determinative. I know what you're going to ask me.
So it sounds like, though, in your experience, you would say in different cases, different things turn out to be the most important. So maybe in one case, voir dire was important because they took too much of a risk with the juror who they left on. Sometimes opening statement, maybe the way the cross or direct goes.
Well, I was going to say, in a couple cases, memorable cases, I believe that the cross-examination was everything of the opposing, either the opposing party or the opposing expert. There are many cases where the party can be. Very many cases where the party's testimony is nearly worthless in terms of the case. And lots of those are med mal. Like if there's a surgical mishap,
right,
out, he can't give us any input in terms of what happened.
Right.
And so I say I don't say it's meaningless, but it's not helpful to the liability issues. And so can impact an expert, then that's really going to be the way that you win the case, one side or the other. And I have seen many cases where really great cross-examination of an expert witness wins it. I saw a case, an automobile case, where the cross-examination of the plaintiff was really super effective also. And I believe that undermined the case. In fact, I've seen a couple of those. One notable counsel that we have in San Diego, I don't know if you want me to name names, but perhaps I shouldn't in this particular instance, because he put on a good case with a good direct testimony with his client, a plaintiff in an automobile accident, but the Facebook destroyed his case in terms of damage. And it wasn't the client's Facebook. It was all the client's friends and family's Facebook of him literally surfing on the back of dolphins in Florida while he's saying that he's got all these very significant injuries, and people, writing to him, wow, you look great in this. That must have been a lot of fun. Yeah, I'm playing tennis and all this sort of stuff. So, that in a case that was an admitted liability case, that ended up being determinative of the outcome in terms of the amount of damages, which were negligible in that case.
Okay. And so let me ask this, in any of your trials, because we've covered a lot of the aspects of the trial, but have you ever had the impression that the final argument really made
Absolutely. Absolutely. Okay. I would say the final argument is super important. Although I'm laughing a little bit because I remember trying a med mal case, and I've had this both ways, by the way. I've had people say, I got my client dismissed from a case once, and the jurors were saying, we were so disappointed because we wanted to hear what you had to say. We were sorry that you got dismissed from the case. But the other side of that coin is more pertinent to your point. I had people say to me, we were just groaning when you came up to do your closing argument, because in your opening statement, you had given your theme so many times. And with each witness, you'd given your theme several times. And we knew what you were going to say. We just didn't want to hear it again, And that was a victory case. But the point was that if you are pursuing your theme properly, they're going to know what you're going to say. And in this particular instance, they like me, but they said, enough's enough. We know what you're going to say. So in those particular instances, closing argument may or may not be the thing that determines the case. but I have seen cases where someone has made really pertinent points and kind of changed my opinion in terms of what was going on. And so if it changed my opinion, then my bet is that an effective closing argument can almost bring you from rags to riches sometimes if you do it properly, you know.
Okay, well, that's great. Well, those are great examples, and thanks for those answers. That's
Yeah.
wonderful. Now, let me go to another issue. You know, a lot of lawyers who are not that experienced, and I was probably this way when I was just starting to try cases, but
Mhm.
I think that lawyers may not know, if they don't have experience, the importance of credibility in trial. So when you're a trial lawyer, in your experience, both as a trial lawyer and a trial judge, how important is the credibility of the trial lawyer in persuading a jury?
I think it's very important. Monty, I have to give though more credit to the jurors than many do. You know, I have I got privy to when I was a defense lawyer. I got privy to an article that was written by a very fantastic plaintiff's lawyer in town. I'll just say his name, Christian Hulbert, and he was describing a case. In this is in the private plaintiff's communication vehicle, whatever it's called. I don't know what it's called. And I was a defense lawyer, so I probably shouldn't, but someone gave it to me. And the theme of it was I was better prepared. I had a better case. The facts supported me, and I lost. And the defense lawyer was a typical defense lawyer. And this is not my words because I was a defense lawyer. Typical defense lawyer, a bean counter, no personality. Da, 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 da. He wasn't as prepared as I was, and I lost. And I'm still getting over the trauma of that, you know. And you know, my thought was, and if I never talked to Christian about this because we're buddies, would be that every once in a while, the jurors pay no attention to the lawyers and just they literally stick to what they believe the facts show, and they make their decision based on that. And so there are times, I think, for the great part of my experience, I believe the jurors I can't say they were unaffected by the lawyers because the lawyers are the vehicles by which the information gets transported to them. Uh, so you need to be an effective transporter and interpreter of the facts that you have. But for the most part, I believe the jurors rely heavily on the facts. And yes, there are situations that I've seen. I can think of two cases in particular where the lawyering and the presentation of the evidence in such a convincing way and the lack of pushback in both cases by the defense caused a huge verdict in each case that I believed was undeserved. You mean the amount of damages? Because the lawyers were not aggressive enough to push back and didn't present their evidence in the same appropriate, organized, and convincing style as the plaintiff's lawyer did in those cases. You know, so yeah, lawyering can make a big difference in terms of outcome. But I'll stick to my theme, and that is that the facts that get before the jury in most cases are going to be determinative.
Well, one of the questions about credibility, though, is if a lawyer doesn't develop credibility with the jury, even if they have good facts and a good case, it can hurt
Yes.
them. And if a lawyer's client doesn't have credibility, it's going to hurt them. And if
Yes.
the lawyer's witnesses or expert witnesses don't have credibility, that hurts too. So, I mean, that's all a part of the jury assessing
Right.
the facts is
Yes.
credibility of the witnesses.
You were talking earlier about you know, which part of the trial is most important, and again, in at least one very highly publicized media case, I believed that the testimony of the defendant was and the cross-examination was what really swayed the jurors, thinking that you really I don't think we can trust what he says. I don't think he's telling the truth. The lawyers were very good, but the client And I think part of this was cultural, to be honest, but the client just couldn't answer a question,
Yeah.
straightforward. He was
Yeah.
very smart, very well dressed, very cultured guy, but just could not answer questions. And I believe that was determinative. So yes, credibility is important. And I can tell you this, Monty, also, when people can't wait for Monty McIntyre to get up and do a direct examination or a cross examination, I go back to this this guy Michael Schoenbuck, the guy, there's a gentleman, an attorney I was looking up before we got on started this program.
Yeah.
I couldn't wait. Every time it was his turn to do something, I, as the judge, could not wait to see this guy. And I think I described him to you as Cousin Vinny after the movie's over, going to Yale Law School trial practice course, and then trying another 40 cases. This is what Michael Schoenbuck was like. Just fantastic and very theme oriented. And I literally couldn't wait for him to get up and do the next exercise in court. Now, if I am feeling that way and I'm the judge, having seen a gazillion of these things, imagine how impressed the jury was with him and how we're listening and trusting him. So credibility is everything. And so what I would, along those lines, if I could pass along advice to people, it would be, and I think, Monty, this was your style as a trial lawyer also. I want to come off as supremely confident with my case and nonplussed about anything the other side is doing, no matter how in real time, how offensive it is. I want to act like it's not a big deal. I want to still be polite to my counsel. And I want the jury to want to hear me because I was so professional and so nice and gentlemanly during that trial, which of course is the heart and soul of our ABOTA principles too.
Yep, heart and soul.
It works. It's not only a way to live by as a lawyer that's going to make your life easier and make your reputation better, but you're going to get better results in front of the jury because they're going to want to hear what you have to say. What better thing to happen in a jury trial when you are trying to essentially advocate your client's position, to have the jury want to hear what you have to say? And what better way to do that by being super professional, nice? If you can, I don't recommend this for everyone, but I was able to insinuate a little humor into my different parts of the trial. And that ended up being super effective for me. And I actually do that as a judge too. So, and the jurors tend to say, I've had many jurors say at the end of a trial when I excuse them, "Judge, can I say one thing?" "What's that?" "You really made it fun for us. Appreciate that." And then they walk out of the courtroom, and that makes my day, that it wasn't all for naught, So yes, your credibility is really important if you want people to listen to what you have to say.
Well, let me remark about a couple of things you've said, because I agree with you so much. First, I agree the ABOTA principles are you want to be reasonable, professional, courteous at all times to everybody in the courtroom, judge, bailiff, court reporter, jury, opposing counsel, witnesses. And that makes a big difference. Another thing that I think is really important, you got to be yourself. And that's what you were talking about with, use some sense of humor because you're Ken Medel and you're good at that, but you can still be serious and get the job done. And I think part of this professionalism is you're being nice and courteous. Well, one of my goals in any trial was I don't want anybody to out nice me. If the other side is equally nice and pleasant and professional, it's a draw and that's fine. But it's surprising how often, if you're just pleasant, courteous, and nice, you are in the plus column and the other side's not being that way. Isn't that amazing?
Right. I have to tell you something about that, Monty, that I think might be interesting. And that is, I had a case as an attorney where I wasn't going to win the case. It was a matter of how much damages we were going to pay. It's the only case that I ever tried that was like that. And I tried it because of a personality difference between the lawyer, the plaintiff's lawyer, and the insurance lady. They hated each other. This case should have never been tried. But the oral surgeon came in and anesthetized a tooth upper, the second one on the top, in the back, and said to this African-American lady who was a patient, you seem a little nervous. Let me give you a little Valium to calm you down, and I'll be right back." And he went out of the room, came back, and he pulls this tooth
Oh, no.
that didn't have the local, anesthesia on there. So that was the case. Pulled the wrong teeth. So we did the whole trial, and my argument was this lady's gums were so bad that almost all of her teeth had already been pulled, that it had no cosmetic function because it was in the back. It had no eating function because it didn't have an opposing tooth to squash the food.
Mm.
And it was literally 3 seconds of some pain of it being pulled out. So you're going to pay her for 3 seconds of pain, and the part that's responsive to your comment is the plaintiff's lawyer gets up there, and here's how he started. He says, "Ladies and gentlemen, there are things that are disputed here, and there are things that are not disputed here. One of the things that's not disputed here is that Mr. Medel is probably one of the nicest human beings that you ever want to meet." You saw that. I saw it. I've seen that. This was in El Centro. So he says, "I'm not sure it was like city slicker fake niceness or not. But either way, it came off as really, really nice." Now, what you need to do is separate Mr. Medel from his client. We'll call him Dr. Mengele, who was, that's so, you could tell that at least, being professional and nice to the greatest extent did cause some worrisome feelings on the other side, that they're going to decide the case based on me and not my client, which they did not do.
Yeah. Sometimes even the nice guy can't save the ship.
Yeah.
Well, Kenny, Judge, before we go to the trial itself, let me just give a couple of tips here to listeners. So if you're a trial lawyer, you don't know which case is going to go to trial. And I think any good trial lawyer from ABOTA would say, prepare every case for trial because you don't know which ones. So if you're going to prepare for the beginning for trial, at the very beginning, when you meet your client, when you're starting to work on the case, start thinking about what's your theme, what's your story. Start looking up the jury instructions. What do you have to prove? What do the other side have to prove? And then when you do your discovery to find out who are the witnesses, get all the documents, take the depositions of all the lay witnesses, and then later you can take the expert depots. And so then the essential stuff, and make sure you get ready for the trial readiness conference where the judge, like Judge Medel, they're going to want you to have a joint exhibit list worked out, talked about with other counsel. They're going to want you to have a joint witness list, a brief statement of the case. And then I would say in the final preparation for trial, might be a month or however long you need to prepare for a trial, you really got to closet yourself and focus on, okay, what are the story? What are the themes? You got to pare your facts down to the essential facts that will be a compelling story for your side of the case. You got to really know every aspect of your case, all the documents, all the testimony, everything. So you know what they are, find them immediately. You've got them prepared to show them and demonstrate them. You got things like cross-exam, impeachment ready, whether you're going to show a slide, you're going to show a depo clip. You got to get your motions limine prepared. You got to figure out what you want to do for jury selection and voir dire, work on your opening statement, get your exhibits ready, get all your direct and cross ready for witnesses, do your jury instructions, prepare your final argument. And you have to be as prepared as possible because if
you're making me really tired thinking about those days, Monty.
Yeah, you remember how hard a work job it was.
Yes.
I called it the grind, where you've got to just closet yourself and work your butt off to get properly prepared. You did that every trial, didn't you?
I did, and I did that when I was a prosecutor. Ironically, when you work for the county, which I did, they don't like you to work overtime. And they literally tell you, do not work overtime. If I did work overtime and I wanted to get paid for that, they would pay you on what's called comp time. So it would be additional like vacation time for many. If you did 2 hours overtime, they'd give you 2 hours comp time. It did not matter to me. I never asked for comp time at any time. What was necessary was for me to get ready for that trial. And even if it were a petty theft or a drunk driving trial, I put my heart and soul into that and did all those things that you just said, absent a few of the civil components of it, to really do the best we possibly can. You know, part of it is not a good work ethic or high professional standards. Part of it is insecurity and knowing you're going to have to stand before 12 or 14 people and look good and, you know,
Right.
not look bad. I mean, those.
Well, I agree with you, Judge. My biggest fear before any trial, even though I was working my ass off to get ready, was, am I prepared enough?
Exactly. For every eventuality, you know. And
am I prepared enough? And actually, the beauty is, if you do that hard work and you are prepared, then once the trial starts, you kind of can get in the flow, because you got to just do things and react, and stuff happens that you don't know is going to happen. It's not going to go the way you're going to plan it. Exactly. But you're in the flow and you're prepared and you're ready. But you got to do that hard work to get ready. Yeah. Otherwise, you can't be just trying to figure out your case in the middle of a trial. Right. Okay, so let's talk about some of the aspects of the trial, and then if you got any tips you want to give to lawyers who haven't tried a case or have very little experience, let's hear what your thoughts are. How about any tips to these less experienced lawyers about motions in limine?
Yeah, you know, here's what you should be thinking about when you're thinking about motions in limine. You should be thinking about, if this particular issue comes up in the middle of trial, is this going to cause a substantial time disruption to the case? And guess what? Affable, fun-loving Judge Medel only gets angry when something happens to interrupt the enjoyment of the jury. And if you come up and an issue pops up in the middle of trial that I think, why wasn't this briefed beforehand? Why does this jury have to stand out in the hall for an hour while we go over this issue? Judge Medel's not going to be happy, and he's not going to be happy because the jurors are not having a good time with you wasting their time. So kind of overriding principle number one is something specific going to disrupt the process of completing the trial in an orderly, appropriate fashion? So if that's the case, motion in limine, okay? The other thing that, Monty, you and I talked about before we began is the God-given gift called Evidence Code Section 352. Evidence Code Section 352 says, hey, judge, when something comes up during the trial in terms of evidence that has the potential of being super overly prejudicial to a party, or it's going to take an inordinate amount of time to resolve or to put on, or it's going to completely confuse the jury, weigh those three factors against how important the evidence is. Do a balancing test. And if you go, well, this stuff's not that important, it's not that important in the big picture of this case, then I can exclude that from testimony. If I feel that even if it's a very saucy, sexy piece of evidence that would otherwise not come in, but it's completely integral to the case, it's essential for a fair trial to happen, then it's going to come in. I'm sorry. So here is the tip that I want to give you guys, as Monty suggested. If the evidence that we're talking about, let's say you're on the opposing side of this, if you think it is something that should not be said in the church, the synagogue, or the temple, for example, you wouldn't stand up and say, I just want to let everyone know that in the church here, that our brother, my neighbor John, just got arrested for child molest the other day. That's something that you wouldn't say. You wouldn't say that he's been taking drugs for quite some time, or that he's been beating his wife, or that he's been arrested for drunk driving, or all of those things would not be things that you would volunteer in the peaceful, holy, sacrosanct environment of your church, temple, mosque, whatever it is. You wouldn't say those things. If it fits into that category, I need to have a 352 motion in limine so that we can decide that thing before you just spit it out in the middle of my trial. And that's going to also be something that's an irritant to any of us judges here. And, you know, we don't want to have to unring bells to the jury either. So again, the principle, if you wouldn't say it in church, then it has to be a 352 motion. Now, one other corollary to that, Monty, if you don't mind. I specifically made our hypothetical that this was a defense lawyer, let's just say, that was objecting to what a plaintiff's lawyer wants to put in. But if the plaintiff's lawyer is preparing in the methodical, energetic manner that you described earlier, Monty, and he sees this, I have a piece of evidence that's really important to my case, but it's got that character that Judge Medel talked about. It's something that you'd never say in church, you know. Then you can do a motion in limine to admit the evidence. Right. And what you're saying is, Judge, I'm with you. I realize that this piece of evidence is 352 stuff. It could be prejudicial. It could be time consuming. It might confuse the juror, but it is so important to my case that this would be like leaving the face off the Mona Lisa.
Yeah.
That's the whole point. And this is so critical to those issues that despite that fact, it needs to come in. And you have a full briefing and you can argue it in a nice, relaxed, calm session and convince the judge that it should come in. So you can do an affirmative 352 motion in limine to admit evidence that. So both sides should be highly aware of that and to bring those to the attention of the court beforehand.
Wonderful. Great tips on that. Thank you so much. So let's go and think about, you've done your motions in limine. Now you're starting the voir dire and you're going to ask questions to the potential jury panel. What kind of a pack do you use in your trials?
We have, I believe, 16 in the jury box. So
okay.
Now, this is something, if you come into my courtroom, I don't want you to be surprised about this. But let's say we're going to do a longer trial and we have 4 alternates. So we have 12, 1 through 7 on the top. I'm sorry, 1 through 6 on the top, 7 through 12 on the bottom row. And then right next to them on the right, there's 2 more seats on the top. That's 13 and 14. And then right below them is 15 and 16. Okay. Yeah. So if, let's say, we're going to have 4 alternates, unwittingly, those 4 people that sit in those seats, they'll never make the panel. I tell the lawyers that they will never be on the panel, at least as we select the jury right now.
Yeah.
So I start substituting from the audience. So what did I say? We had 16 in the box.
Right.
We have, I think, 4 rows, or is it 3? I can't remember. But we have, we fill up the left side, the jury side audience section. We fill that completely up with jurors. So it ends up being 35 jurors.
Oh, yeah. Good sized panel, potential panel.
Every trial.
Okay.
And so what I do is, if we have to excuse someone, then we start from the first seat, which is going to be number 17 in that audience section. Yeah.
So you'll say if somebody says excuse number 1, 17 goes to 1.
That's right.
Somebody excuses another juror, 18 goes there. Okay. Exactly. Gotcha. So what tips, if any, do you think inexperienced or not very experienced trial lawyers need about picking a jury in voir dire?
Well, first of all, be yourself. That's part of this is establishing a rapport, a conversation with these jurors that will hopefully carry on through your examinations, especially your direct examinations, where you're continuing this dialogue with this jury. So be yourself. It's more about things to avoid. Let me give you what I believe jury selection is about. In fact, it's not what I believe; it's what jury selection is about. Number one, you're looking for people to be fair, and a subcategory of fairness is going to be whether they are biased, and bias means they like someone so much that they can't be fair. Like, Monty, I love you so much, and you're a party of this. I don't think I can be fair. I'm going to go Monty's way no matter what. That's called bias. And then you all know what the opposite of that is, and that's prejudice. And that is, I had my own case, and I sued someone, and a devious defense lawyer was on there, and I hate defense lawyers. I just think they're terrible, and this sort of thing. So that's prejudice. By the way, I'm just giving examples. So I was a defense lawyer, so don't take it the wrong way. So
well, you could say, Judge, is I've also said jurors have bias, good bias and bad bias.
Yeah, either way, it's a matter, it's just terminology. But the
Yeah.
bottom line is your voir dire is focused on whether people can be fair to both sides. Okay.
Right.
Then it's focused on whether people can be competent. Some people maybe have certain, for example, might have just gone through this same trauma earlier themselves, and they will make them feel horrible to sit through this trial. So they can be fair. It's just going to be horribly traumatic to them. Other people, and this is usually something that I deal with, have physical disabilities. They can't hear, or they need to go to the bathroom every 10 minutes, and they feel it's going to be disruptive or whatever. So all of these things, competence, that's kind of competence to sit there. Maybe they don't speak English very well. So all those are competence issues. And then fairness issues, bias and prejudice and ability to be fair. So you can explore things in their life that might relate to those issues. Now, in contrast to that, Monty, what I'm seeing, and I've seen it for years and years, so it's not new, is that people are really trying to use jurors as innocent shills to promote a theme. Inquiries that have nothing to do with bias, prejudice, fairness, or competence. Nothing. And it is a natural mind of a lawyer that does this, and it happens in every single case. But if you are doing that, then I'm going to sustain an objection, or I'll probably just, if it's really irking me, I might just say, Mr. McIntyre, let's move on to a different subject now, okay? Or something like that. So, if you're insistent on promoting a theme, let us get to the point. So there's a in-a-court case that they use every year that you're doubtless familiar with, and that is the dentist who took her kids up to the mountains, and instead of walking on the lighted path, she decided in the deep of the night to go through the forest, wood trail, and dark. She falls in a pit and breaks her surgical arm. So she can't anymore. And of course, there's a good affirmative defense of contributory or comparative negligence. And what would happen every year, Monty, defense lawyers would get up and they would say this. They would say, who runs for exercise? And several people would raise their hand and go, Mrs. Jones, let me ask you something. When you run for exercise, do you usually run at the same time every day? She goes, yeah. What time is that? She goes, well, it's usually like 7:30 in the morning when I get up. Okay. And you do that because it's light out. You can see, right? Yeah. You kind of avoid running in the nighttime, don't you? Yes, I do. And you usually take the same route on the street every day? Yes, I do, right around my house. And you do that because you know what to expect, and you're familiar with the area, correct? Yes. And You would never like run down a dark alley at 12 o'clock at night and not knowing what was there and that sort of thing, right? Yeah. And then they actually always give the big question. So if you should run down a dark alley against your better judgment in the middle of the night, not knowing what dangers faced you, and you tripped and fell, you would consider yourself responsible for that, wouldn't you? Okay, I'm going to ask everyone listening to this, what did any of that have to do with fairness, competence, ability to serve, physically ability to serve on this? It had nothing to do with it. So, Monty, when I give an example of the wrong way to do things, by the way, it's a brilliant cross-examination. It's brilliant.
And you can make the argument in closing argument.
Yes, you can do it on cross or closing argument. But
Yeah.
it has nothing to do with jury selection.
Yeah.
If you do that, that's not right. But I don't like to give bad examples without giving good examples. So Monty, you're the juror, right?
Right.
You raised your hand, you run. And I said, do you run, sir? And
yes.
your answer, and I take it you do it in a way to take all precautions, to keep yourself safe, correct?
Yes, I do.
All right. You've heard that the plaintiff's going to claim that we were negligent. My mountain resort was negligent, but we're also going to put on a case, and we go second. And we're going to put on a case that includes our allegation that the dentist was negligent also, because she didn't choose a safe place to run, kind of like you do. She didn't choose a safe way of doing it. Would you be open to hearing our side and considering the facts about that and be fair to our side?
Yes.
All right, so I've transformed it from a long cross-examination. I quickly went from my example to a fairness issue, and boom, you've covered what the same thing you wanted to do without the judge getting mad at you.
There you go.
All right.
Judge Medel would not get mad at that. Okay, so now we've picked our jury, and now we're going to be able to give our opening statement. Do you have any tips for lawyers about the right way to do it?
Well, again, Monty, you and I talked about this, and both of us, to be honest with you and to be gentle, we're getting a little old here.
Yes, we are a little long in the tooth and experienced.
So we're both old school guys. And, the rule of opening statement is that you are presenting a set of facts that matches the evidence that you're going to be presenting. Remember, evidence is just a fancy word for information. So you're providing the jury with a factual account of the information that you're going to be providing them during the course of the thing. So it should sound like Grimm's fairy tale, really, technically. Now, one sort of exception to that is in civil cases, a lot of them are expert heavy. And so you get a chance to, and my expert's going to say, this was the worst case of medical malpractice. You're able to say that because that's what your expert's going to say. So it kind of bootstrap some argument into that. And, if you start with a theme, I recognize that as craftsmanship. And even though it's argumentative, I'm going to allow you to promote your theme. And I'll probably allow you to promote your theme about 3 or 4 times during your opening statement. Now, you don't have to promote your theme by saying your theme. This is the story of a jealous lover. So maybe that's your theme. You don't have to keep saying this is a story of a jealous lover every time.
Right.
You use your facts to show he was a jealous lover.
Yeah.
And that's how your theme gets repeated throughout the thing. So I am tolerant of hearing a theme 3 or 4 times during your opening to keep it glued together. But otherwise, you need to just tell us what the evidence is going to be, maybe identify your witnesses, and then conclude. I would allow you to conclude saying, here are the causes of action now. You can either do this at the beginning or the end. We're going to be claiming negligence. We're going to be claiming assault and battery. We're going to be claiming such and such. And at the end of this, we're convinced that you will find in favor of plaintiffs on all 3 of these. And boom, you're on your way. But, the art of an opening statement is to organize your facts and use words that not only tell the story, but convince the jury of your legal position. So that's
Right.
the art of in a play, in a Shakespeare play. These are masterpieces that have survived the passage of huge amounts of time. He
Right.
never gives a theme. He never gives a theme of in Hamlet of this Oedipus thing that's going on or whatever. It
No.
speaks. The facts speak for themselves, and so that's kind of what you want to do is make
Well,
your.
I think, yeah, I mean, that's part of the creativity and the process of figuring out what's your compelling story.
Yes.
And your opening statement is a chance for you to do it in a very succinct way, tell
Right.
the facts, and the facts should be the facts that are persuasive. But I also like to say you need to tell a story where you're kind of creating word pictures in the mind of the jury where they get it. They understand.
Right.
They go, yeah, that makes sense.
I want to talk about one other thing, sort of two other things that are related. I've never seen a theme greater promoted by this guy Schoenbach, that cousin Vinny guy, the polished up and perfect cousin Vinny guy. And Michael Schoenbach, who basically his theme was that his client's story never changed. It was the same story from start to finish, and he started that right at the beginning, and then went through and said, here's what. Now, on the other hand, here's what the defense said. The defendant said, and he had a different story when the police arrived, a different story when he talked to some friends at a party about the accident, a different story at trial, and he didn't have different. He said, and now here's what he said. Now here's what he said, and that was his theme all through this trial, is that my client has been solid, and she wasn't any kind of spectacular witness. She was a very everyday kind of woman, but that theme was really promoted through his opening statement and carried all the way through the end at the trial.
Right.
The other thing I wanted to mention about opening, I think you might be getting this into one of your points later, but it's the use of technology during opening statement.
Yeah.
And so just a couple of hints. If you're going to use technology, rehearse, so that you are coordinated with your PowerPoint or whatever it is you're going to use.
Absolutely.
Sometimes videos, films, and those sorts of things. You need to rehearse. If you can't do it yourself, have someone come and operate the machinery.
Right.
I don't want, then that goes from the point of you wanting to do it to the point of you doing it. Meaning, don't come in 5 minutes before you're supposed to do your opening statement and go, Judge, I'm sorry, I need another 20 minutes because my machine doesn't work, which happens more frequently, Monty, than you could imagine. So get it done early, get it done right. You can rehearse in court if you want, go through it. I don't care. Use my courtroom to do it, but be coordinated, be super coordinated with your audio-visual stuff that you're showing. To that, I want to say, there's a guy in Panish's court, Panish's law firm, named Robert Glassman, who at the time I saw him, which was several years ago, I perceived him to be a relatively new lawyer. I've never seen the audio visual so connected to someone's brain. It was as if AI had advanced to the extent that it could read what was in his brain as he was showing his visuals, because they were so well coordinated. And there was a lot of it was a back injury case, so there was a lot of videos about surgical screws being placed and all that stuff. But if you can get to that level of proficiency by coordinating your words of your opening statement with your audio visuals of your opening statement, wow, that was a super powerful opening statement.
Great tips. When I was trying cases, I would always use graphics, and a lot of lawyers don't want to try to choose the exhibits, and they want somebody to open them up for them. I was comfortable opening them up, but I always hired a company to bring the equipment, was there in case anything happened, needed to be fixed. And like you said, you got to practice, so you know where everything is. You can change on the fly if you need to, and you can bring it up. And that graphic presentation can really be powerful. and
Yeah.
you use that well. So great tips. Thank you for that.
Right.
Now, what about any tips on direct examination in trials?
Woof. So I have to brag a little bit, and this is internal bragging because people don't see this because it just happens and it looks smooth and everyone goes, "Oh, that was nice," and they don't see the effort that went into the preparation there. I'm going to start, Monty, on this subject by telling another crazy story. John, have you ever heard of Johnny Carson, Monty?
Yeah,
Who is the equivalent now of Johnny Carson? This is for our younger audience here.
I don't know.
Jimmy Fallon probably would be the best.
Maybe Jimmy Fallon.
Took over his show. Johnny Carson had a guest on his show named George Burns. Monty, do you remember who George Burns is?
I do.
George Burns was a very old, I've never seen him when he wasn't old, but a very old comedian who was of Jewish heritage. He came from New York, and like many of the Jewish comedians that came from that area, they were up in the Catskills, these resorts doing their comedy long before movies and TVs and everything else, you know.
Yep.
That old. One night he came on, a little short guy, bad gray toupee, always with a cigar in his mouth. Came and walked, and he sat on the first seat. And Johnny Carson said to him, "Well, it's so nice to have you, George. Before we get started with the interview, I just want to tell you my staff's done some research on you, and they're finding out that you're smoking. Oops, sorry about that. You're smoking about 8 of those cigars a day. That you're drinking a quart or more of whiskey every day, and that you're keeping some very long hours with some very young women. And I just want to know, what does your doctor think about that?" And George Burns looked at him and he goes, "He's dead." And so, the audience really liked that. I was cracking up. And I've thought about that scene many times, and it seemed so spontaneous. But then I pictured in my mind what had to happen for that to work. Because Johnny did it perfectly. He was the perfect setup man, and then the joke came.
Yeah.
So I pictured the green room. And in the green room, there's George Burns, and the staff is getting his makeup on for TV and all that. And Johnny drops by and goes, "Hey, George, you haven't been on in a long time. Good to see you. I'll see you out there." And George Burns says, "No, Johnny, come here." And he goes, "Here's what we're going to do. You're going to say this, you're going to say this, and you're going to say this, and then I'm going to say this. You got it? You want to try it once? No?" And boom. And then that's what made it so perfect. So all I'm going to tell you is your direct examinations, first of all, sorry about that. First of all, with your client, there needs to be a lot of preparation. Monty, you and I talked about this. I was a Medel lawyer. I had the fervent belief that I was not going to win if my jury didn't like my doctor. So I had a rule in my brain. My standard of care was a 3-step preparation process for my client's direct examination. This is a doctor. Number 1, we meet just like you and I are meeting now, Monty, and we just bounce ideas off one another.
Right.
Then I go back to the office and I make an outline. I organize what we talked about. Meeting number 2, you and I go over the outline. You're looking at it. I'm looking at it. We're moving things to different places. The doctor's saying, I don't think I would say that. That's not that important. Ken, you said the same thing twice. Do we need to say it twice? And we take that out. And then we're finished with that part of it. And then I do a new outline that's now has all the editorial changes in it. And now I bring my client into my office with all of my staff, all of my attorneys, and I conduct a direct examination on him just the way we planned. And when we're done, we get feedback from everyone in the room about what they thought about it. Remember, your legal assistants and your paralegals are more attuned to the jurors. They're more like laypersons than you are, with all this
Right.
distorted personalities we all have by being lawyers. So you're getting better feedback from lay people than you are from people who are super trained in the law like we are. So that's helpful. And then I do a cross-examination, and I would always, pompously tell my client, I'm now going to cross-examine you 10 times better than the plaintiff's lawyer in this case is going to cross-examine you. Okay, here we go. Because I'd
And
prepared
you probably did. Yeah.
So when that was done, that was the most revealing process because we hadn't planned it like we did the direct, right? And
Right.
stuff would come out that was unbelievable. That was unbelievable. That really needed to be adjusted, and how defensive people get and this sort of thing. So that was really, really important too. At the end of that session, we were ready. I was confident that we were ready for trial, and I handled a lot of people with challenging personalities, and it always seemed to work out well for me with that preparation.
That's great preparation.
Yep.
And you got to be prepared for direct. You can't just go out there and wing it. Now, when we were talking before we did this interview
Yep.
today, you were telling me some horror stories about some things you've seen happen in trials, like lawyers who haven't done a depo and they're just taking testimony like it was a depo.
Yeah. So two things, Monty, on that scale. Number one, I have been, I'll say, surprised by the lack of coordination between the client and their own lawyer,
Right.
and such that there is so much confusion. It's like, when did you do such and such? I'm not sure what you're asking me. No, and there's this back and forth between the lawyer and the client where they're not even understanding what the question is, and it goes on and on and on. And it's clear to me that the client is not prepared for the questions.
Right.
Thinking about them on the sly, for hearing the questions for the first time. That is astonishing to me, just to be frank, when that happens. So it goes contrary to what we just said.
And what you would say is part of the proper preparation for trial that we've talked about is you got to prepare your witness.
Yeah. And the second thing, Monty, is and by the way, on preparing witnesses, I want everyone to know this is a big thing for me. I want everyone to know that is if you have an ethical and moral opportunity to interview a third-party witness and get to know them and find out what they're going to say and let them know what you're going to ask them, you do it. You might not necessarily need to take a deposition. Just what I would do is, I told Monty this, I would call them up. I'd say, you're going to be testifying in this trial because we subpoenaed, but I wanted to meet with you just to find out what you know and what you saw, what you have to say, and that sort of thing. And I would say, where's the nearest Starbucks to your house? Or is there a restaurant? Or do you want me to meet you at your home? I don't care. Well, where it is. And I would go there at an environment that was friendly to them. And we would go over what it is they had to say. And if I had prepared an outline, which I usually had, of what I was interested in, I would go over that with them and tell them, well, here's what I'm going to be asking you. Now, important, listen, tune up your antenna right now, please. This person's not your client. You can't say stuff like, yeah, I'm forced to try this case because my client won't consent to settlement. It's the worst case I've ever had. Because if you say that to the witness and that witness remembers it, they might be duty bound to repeat that. There's no attorney-client privilege when you're talking to a third-party witness. So you have to be very, very careful and circumspect when talking to a third-party witness. And then finally, on this subject, I think it's fair to tell the witness it's likely 50-50 that the fact that we met is going to come up at trial. And the other lawyers kind of try to make a big deal like we were colluding or conspiring. But don't let it go that way. All you need to say is, Mr. Medel wanted to know what I had to say, and he wanted me to know what questions I was going to ask him. And the bottom line is, he told me to tell the truth. And that's all I can tell you with what that meeting was about. And I think that I've never had a problem with that ever. So if you can coordinate with third-party witnesses, that's great. The last thing is that we talked about, Monty, is I am seeing testimony now where people on cross-examination are asking all of these open-ended questions, violating the very core principle of cross-examination.
Okay, so we've blended across. That's great.
And it goes on and on and on and on. And finally I go, can I see counsel in chambers? Because it's taking too much time.
Yeah.
And he's never getting a yes answer to his, and he's asking, why did you do this? How did this happen? And I take him back and I go, counsel on cross, did you depose this person? He goes, no. And I go, well, you're not, cross-examination is supposed to make 3 or 4 points and then sit down. You're taking a deposition in my courtroom. And if it were just me, that would be irritating, but it's in front of a jury. So now it's enraging, because that's the only thing that gets me mad is when we're wasting the jury's time. You're taking a deposition in my courtroom right now in the guise of it being cross-exam. We're not doing that. So let's have your questions be pointed. Remember, God gave you the gift of leading questions for cross. Use them and let's get out of here. Maybe that segued into cross, but there we go.
Well, yeah, I mean, so thanks for those tips too on cross.
Yeah.
You have to prepare for cross, but like you say, you want to use leading questions, you want to control the witness, and you only want to make some key points. You don't want to go on a fishing expedition, right?
Right.
Okay, that's great. Wonderful tips. Well, let's go in terms of the trials you presided over. Any tips to no experience in trial or little experience in trial on what people should be doing in final argument, closing argument?
So, closing argument is truly, I think it is the most unstructured art form of all of the. Close second is voir dire.
Yeah.
At least written out your questions for voir dire, and you kind of know what you're going to ask. But I've had Paul Finkst is one of our premier trial lawyers in town.
Excellent trial lawyer.
And we have talked about some of these issues, and he has commented in a pejorative way. I've seen lawyers just go right down the elements of the cause of action and then talk about the evidence that pertains to each element. And he goes, I can't believe they did that. As if it were too structured, too mechanical, too robotic to do it that way, and not artistic enough, And I can say that I don't think I've ever heard a closing argument by Paul, but his reputation speaks for itself.
I tried a case against him.
Yeah, but I think there is some merit in that. So closing argument gives you a chance to be relatively creative and uninhibited and just say what you feel. But you do need, at some point, on both sides, at that point in the trial, to start talking about the law.
Yeah.
About the causes of action, how the evidence fits into the cause of action, either have the evidence having proven those elements or not proven those elements.
Right.
And talk about the credibility of witnesses, and talk about the value of the evidence at that point. And then get your theme in there, how it all fits into your theme.
Right.
And then end with a big bang at the end, that sort of thing. So there you go. I just, I'm going to leave that fairly loose, but I kind of did it. I was kind of surprised when I talked to Mr. Finkst, because that's kind of the way I did it. I would say, okay, mine were admittedly easy structures, med mal. Was there negligence? Was there causation? That's all I ever talked about.
Right.
So,
and you could do that. Well, Judge, one of the things that I've come to believe in the cases I tried is I always felt that whether I was playing for defense lawyer, and I've been both, I always felt that in the opening statement, you had to be more just factual, reserved, and this and that. But by the time you got to the end of trial and you were making your closing argument, you could bring some appropriate emotion in at the appropriate places, and the jury could accept that because they knew the case then, they knew everybody. But I think that's a time to do it, not at the beginning.
Right.
Another thing, I think you better explain to them the verdict form they're going to be given, and explain how you think they should answer it and what your thoughts about the evidence is, because you'll help them get through that process.
Yep. Exactly. I think almost everyone naturally does go over the verdict form on both sides. And
Yeah.
now with the graphics we have, they have the video, they have the verdict form up on the screen, and they even have the check mark coming in right where it should come in according to their point of view.
Yeah, that's great. Well, Judge, this has been a wonderful conversation, and I really appreciate all the great tips you've been giving people. It's going to be very helpful to people. Let's think about this as we close out this discussion, and thank you for your time today. What advice would you give to young lawyers who haven't tried a case or only tried a few on what they should do to become really good trial lawyers?
So I'm gonna kind of move back a little bit before they became trial lawyers and tell everyone that I kind of was raised in a very theatrical way. Going to a Little League baseball game that I was in was a major theatrical event with all my family there cheering me on and that sort of stuff. I was in a band, a musical band, for up to the first year of college, starting in 6th grade. I played high school football. I'm not bragging. I'm just trying to emphasize the theatrical nature, but I caught the, not the winning, but our touchdown that we made in the rival game against Downey High School before 20,000 fans at Cerritos College. So that was a big deal. And then I studied a little bit of drama at UC Irvine. So by the time I got to law school and was stuck in a room studying old English property cases, I was about ready to commit suicide. Or at least, maybe not that bad, but I was thinking I did not pursuing the area of law. I stuck it out with those feelings persisting until my 2nd year when I took my trial practice course. And at that point, I said, oh my God, there is the possibility of surviving this and to have a career in the law if I have a trial performance on the horizon. And so the beginning answer to your question, if you're a law student watching this, is to take those trial practice courses. Now they have mock trial. I don't think, Monty, when we were going to USD, they had mock trial.
They did not.
Moot court, and then they had trial practice courses, but they didn't have mock trial. But if now your school, your law school should have both the courses, the advocacy courses, and the extracurricular mock trial. Get as many trials under your belt as you possibly can, with some guidance from your teachers too. And you're probably going to be critiqued by judges and lawyers in your community when you're in that process also, which is great. Now you've become a lawyer. We have a program that you mentioned, the San Diego Inn of Court. Get in that as soon as you possibly can. This is a hands-on, roll up your sleeves trial practice course. There's no drinking cocktails or mingling or society. This is a get your hands dirty and get in there and do them with really, really great instructors lecturing on these skills: opening statement, closing argument, direct cross-examination, and really good lawyers demonstrating them to you. And guess what? That happens on a Tuesday. And Thursday, you're in one of our courtrooms with a judge in the room and an experienced lawyer where you're actually doing all these skills also. So get into the San Diego Inn of Court. And I don't know, you might be in other states that watch this. So whatever you guys have available to you.
Whatever the equivalent is, but San Diego Inn of Court is the place to start for young lawyers in San Diego. I took it as a first-year lawyer. I was later a demonstrator for the San Diego Inn of Court. I've taught Saturday things. It's a great program. You were involved too.
Now you've done that. Now you need to start asking people who are the good lawyers in town in your field of specialty, and get going and seeing those lawyers do those things. I can literally, and maybe we'll do this in a different video, I can give you 5 or 6 or 7 different examples of things that I stole from other lawyers that I've incorporated into my own style. Monty, I'm wondering, are we still good? Yeah. Okay.
We're still good. Keep going.
By you observing good lawyers in town, you can, it is totally permissible to steal things, techniques from them, and to incorporate them into your style to start developing who you are. And remember at first, I had a judge tell me this. He was bragging about the opposing lawyer being like a holy. He was a Mormon fellow, and he said this guy's spirituality radiates from him. And I said, well, what about me? I'm the prosecutor in the case. And he goes, you don't have any style yet. Because I was only out on one or 2 years. And it was like, you haven't really developed who you are yet. And that's going to be part of the process, part of the road that you're on to build who you're going to be, So don't get frustrated, So watch other lawyers. Second chair. If the partner in your firm is going to do a trial, beg that person to come and second chair.
Yep.
Start getting involved in preparing some of the testimonial outlines so you get a feel for what flies and what doesn't fly and that sort of stuff. And also the American Inn of Court, the Welsh Inn of Court is the one I'm associated with, but we have many Inns of Court. This is an organization started by Chief Justice Berger of the Supreme Court long in the 80s. And it's devoted to, now you're drinking cocktails, all right? But it's more of a collegial, professional. It's both social, but you learn a lot of things about the trial process in that too. So join one of those, and you'll have a lot of fun, and you'll meet a lot of people, and you'll learn a lot.
And I'm a master in the Enright Inn of Court, American Inn of Court in San Diego. A couple other things that people could do to get experience. You can go to trial trainings by different organizations, but National ABOTA, American Board of Trial Advocates, every year puts on a trial college. And if people can go there, and they can also get training from the best of the best trial lawyers. So that's another way that they can get some experience and get some training. Well, Judge, this has been great. Any last advice you want to give?
Just following up on that, Monty, one of the things that I knew that this was going to be my career, that trials were going to be my career, because that's all that I loved. So there are also many books. Old-time lawyers like F. Lee Bailey has written books about his experiences in trial. Vince Bugliosi, who tried the Manson cases. You got to read Helter Skelter. And he also wrote another one too. I think it might have been a critique of the O.J. Simpson prosecutors.
He did write a brilliant critique of the O.J. Simpson criminal trial.
And there are myriad other books by really great trial lawyers that really get you right down into the courtroom and experiencing what they experience. So the bottom line is as much experience as you can get, even if it's by watching people or by books or by talking to experienced lawyers, is going to benefit you in the end. But I just wish everyone to really take your responsibilities as a trial lawyer seriously, but also have fun doing it, because it's a blast. I mean, Monty kind of went through the whole big picture of all the work you have to do, but it's so exciting doing it, to prepare a show for someone. You're preparing, just like George Burns and Johnny Carson, you're preparing a show for this jury to show that your client has a cause, and it's all about justice. So have some fun doing it, and be creative.
Yeah, when you're in that zone, it's a lot of fun, isn't it?
Yeah.
It's great to be in that zone.
Yep.
Well, Judge, thanks so much for being a guest. You have imparted a lot of great tips, a lot of great wisdom. And I also love the fact that you love the law. You've got an enthusiasm for the law as a judge, and you've had it all throughout when you were a trial lawyer. Thank you so much for being a guest today, and I really appreciate it. Everybody's going to learn a lot of great things from this discussion.
It's a big privilege for me, Monty, and I thank you not only for inviting me, but for our many years of friendship.
Thank you, Judge.
All right.